A warm welcome from the heart of Munich at Café Data. Today's topic is background checks for applicants. Employers frequently express interest in conducting background checks on applicants, particularly regarding their financial and personal circumstances. But under what data protection conditions are these checks permissible beyond 2021? More on that in today's video. For background checks, it is first important to note that they involve the processing of personal data. This is undisputed, so we need a justification, particularly consent or legitimate interest in practice. Furthermore, the 2001 principle of purpose limitation applies to the respective examination procedures. Let's take a closer look at them. Let's start with social networks, specifically the question of whether an HR department is allowed to check what applicants have published on social platforms. The principle applies that on professional networks like LinkedIn or Xing, such checks are permissible. On privately oriented social platforms such as Facebook, this is considered impermissible. Then there is the offer on the internet to have all published data about a person automatically compiled. In this context, particularly with regard to Article 22 GDPR, the consent of the affected applicant is generally required. In my opinion, it is generally questionable whether one can truly consent to this data processing voluntarily. And thus, it raises the question for me whether there is a lawful basis for this type of data processing at all. Then we look at the area of criminal records. Not in every country, but in Germany, there is the concept of criminal records. This means that the relevant documents are issued by the state authorities to indicate whether there are any criminal records. Here too there is a distinction between an extended criminal record and a normal criminal record. Here, the principle applies that the submission of criminal records is generally not considered necessary for applicants. Only when the hiring process reaches a concrete decision, essentially after the first round is completed, is it permissible or even required to request a criminal record in positions where there is a particular legal interest or a statutory requirement. Specifically, if they want to hire someone who works in critical areas in any way, such as security, IT, or in any way comes into contact with financial flows, the submission of relevant criminal records from 2001 is considered permissible. And then in other areas, such as childcare, the submission of criminal records is also legally required. Looking at credit or Schufa reports, which involve researching a person's financial circumstances, these should not be part of the application process. Only when the hiring decision has essentially been made in justified exceptional cases, particularly in positions dealing with financial flows, is it permissible to obtain such a report. Then HR departments often also choose the method of contacting the previous employer and asking about their experiences with the applicant. Here too, such contact is only permissible with the prior consent of the affected applicant. The greatest honor one can bestow upon a person, according to Matthias Claudius, is to place one's trust in them. And thus, in most cases, it is possible for the employer to get a comprehensive picture of the applicant through the submitted application documents and certificates. Only in exceptional cases are inquiries with previous employers permissible based on the consent of the individual concerned. A search on professional networks such as LinkedIn is possible. The submission of criminal records is possible when the hiring decision has been made and a special position, e.g., security IT finances are given, or for example, it is legally required when working with children. What else happened? The Pharmaceutical Association criticizes patient rights with regard to European health. More on this in the link. Enjoy reading.